good afternoon to in-house counsel and in-house legal professionals from all across North America and the world. Welcome to In-House Connect. My name is Shai Mahani. I am the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast time or your lunchtime with us. And special thanks to our wonderful sponsors, Tangibly and DLA Piper, and our fantastic presenters today, Chris Buntel, James Pooley, and Ray Miller. We're going to teach us trade secrets for in-house counsel, best practices for successfully managing and protecting trade secrets. This is a huge area of focus. It's a very hot topic these days. This is our 37th event of the year, and I'm wondering, are you here for the first time or have you tuned in to our webinars before? Today's event is Trade Secrets for In-House Counsel, Best Practices for Successfully Managing and Protecting Trade Secrets. We have a wonderful panel. I'll start with three. This is his third webinar with us, and that is Chris Buntel. Chris is an intellectual property attorney with over 20 years of experience, and he is the co-founder and CIPO of Tangibly, and we'll learn more about Tangibly probably in the Q&A section. Chris is passionate about trade secret management and education, and that's demonstrated by the fact that this is his third webinar in this trade secret series. And folks, if you're interested in checking out those other webinars, they're available via In-House Connect on Demand, our live CLE platform. It's $275 a year for all access. So those, if you're interested, you can message me and I can share more information about that. Next, we have Ray Miller. Ray is a trusted intellectual property advisor to clients in a wide range of spaces. He adds value to each client's IP estate by providing clear and pragmatic guidance that allows for efficient navigation of IP opportunities. Ray helps clients identify, protect, secure, and optimize the value of their IP by combining strategic patent prosecution with manufacturing and regulatory exclusivity strategies. Ray counsels materials, science, pharmaceutical, medical device, biologics, and digital therapeutics clients to allow them to obtain a return on their investment. Ray also manages freedom to operate, manufacturing, supply considerations on his client's behalf. His clients include private equity and venture capital funds, pharmaceutical and biotechnology firms, world-class medical and research facilities, and Fortune 500 companies with well-developed intellectual property portfolios. And of course, he's a partner at DLA Piper. And last but certainly not least, we're fortunate to have Jim Dooley. Jim frequently serves as lead counsel in major trade secret litigation as an experienced and trustworthy advisor, a member of the team who combines his scholarship and practical experience to add unique value. Company counsel or in-house counsel rely on Jim to help investigate and assess potential or ongoing disputes. And due to his unique background, his clients benefit not only from his expertise, but also from the efficiency that comes with over 40 years of practice in this field. Trade secret cases by their nature can be unpredictable and difficult to manage, so it helps to have a steady, independent source of seasoned advice. And frankly, I think Jim is one of the most prolific trade secret authors out there. So very, very humbled and honored to have our wonderful panel with us today. And without further ado, I'll turn things over to Chris to get us started.
Great, thanks, Shai. And like he mentioned, this is the third of a series of trade secrets that really reflects how important trade secrets are, and more people are adding it or paying more attention as part of a holistic IP portfolio. So this is just a great panel to handle this topic. And here are the three of us with our contact information. Again, it's a great panel to be part of. And to go over the agenda today, we hope that this is more conversational between both the panel as well as the audience. So we'd love to get everyone talking. But first off, just why is there a lot more discussion and excitement around trade secrets now compared to 5 or 10 years ago? The second one, we'll be talking about an update on trade secret laws and management and why it's important to protect your assets using trade secrets. The third one is about where are your risks and how can you understand where the risks are coming from and at least minimize, you can never truly eliminate risk 100%, but what can you do to lower your risk substantially? And then the fourth one is a discussion about hot topics and some recent case law and kind of our feelings of where the trends are going. I think this is going to be a really interesting year. We're off to a great start. So I'm turning it over to Jim for slides 4 through 8. So Jim, take it away.
Well, thanks, Chris. Why don't we go on to the next slide, which tells us fundamentally why we're paying more attention to a different kind of asset than we used to 35, 40 years ago. In fact, during our lifetimes, we have witnessed the biggest change in the nature of corporate assets since the Industrial Revolution. So what businesses rely on these days for their competitive advantage is talent to the workforce and data. And if you hear people say data needs some sort of new sui generis IP protection, they're wrong, because secrecy is the way that businesses protect their data assets, broadly speaking. So no longer do businesses rely on railroads, buildings, and machinery as their primary asset base. So that's what we're focused on. How do you maintain control, particularly in a digital environment where the information that constitutes your data assets are stored on basically insecure systems and communicated in those systems? How do you keep control over it? So let's go to the next slide. And we'll see one of the challenges we have is that we're dealing with a kind of an old perspective among those who help us do what we need to do inside the enterprise. A lot of lawyers, IP lawyers, and I'm not disparaging them here, but this is just from experience, they tend to look at this issue not from the perspective of business assets or business processes, but from the perspective of legal dimensions and definitions. And so they see patents, copyrights, trademarks, the registered rights as being real IP, whereas trade secrets are this mysterious area that comes from state law. We don't know what doctrines are behind it. It has something to do with departing employees and so forth, but we try not to pay attention to it. And we'll get back to this in a second, but for a long period of time, that was easy to do because when we're patenting, the patent lawyers will tell us, put everything related to the innovation into the patent application, because otherwise you risk that the patent will be held invalid for failure to comply with what they call the best mode requirement, where you have to reveal the best way of implementing the invention. We'll see that has changed. So let's go on to the next slide, which is a more comfortable slide because this represents your reality. This represents the way that businesses actually see data assets and trade secrets. And we have heading up the list here of assets area that we've been talking a lot about in the last year, AI and machine learning data, all of that, market analysis, information about customers, your strategies, deep into your technology for source code, every bit of your R&D, including the failed experiments, which tell you what doesn't work or works less well, your competitive intelligence activities, all of those things represent assets, potential assets, and areas of opportunity for the organization to increase enterprise value. At the same time, of course, they represent challenges for management, particularly in international operations, because the enforcement of trade secret rights is something of a patchwork across the globe. We have issues of internal governance because questions around security of information assets may seem a little abstract to management. That is until they find out that there's a problem, right? So it's one of these silent killers. And so engaging in risk management of the sort that we need to do around trade secrets sometimes involves getting the attention of those who are handling the resources of the organization. And I'll just mention here NDAs, you see, and we're going to be talking a lot about non-compete agreements later. NDAs and the way that they are managed or mismanaged, in my experience, represent the single most frequent cause for business-to-business trade secret disputes, which of course can be very disruptive and expensive. So let's go on to the next slide. Because we're talking about risk here, one of the things that we need to keep in mind is that it's not just about the risk that your information is going to be lost to the world and lose its value, but it's also you live in a dynamic environment where information comes into the company, and sometimes it comes in ways that create obligations and liabilities. And sometimes those liabilities mature into litigation. And one of the things that's happened in the last 10 years or so is that we've seen a very large increase in the nature and the size of trade secret verdicts. You see one here from the court in Virginia last year that came in with a jury verdict of $2 billion. And that's on appeal. Now, the good news here is that most of these very large verdicts get cut back by the trial courts, but they don't get cut back by much. We still see 8 and 9 figure verdicts coming all the time. And so this is something that we need to pay attention to. It's not just the outbound risk, but the inbound risk. What is happening to our data? What is happening to data that we get exposed to? Now, the last thing I want to mention about what's happened and why we're paying attention to this is that back in 2011, effective 2012, we got the America Invents Act, which was mainly about patent reform, but it also made 2 very important changes that affected profoundly the level of comfort that businesses have in turning to secrecy as a way to manage their intellectual property assets. The first of those was effectively ending the best mode requirement. It no longer can be used as a way to invalidate a patent. And so that gives businesses some comfort in holding back relevant and valuable information that's related to the patents that they're applying for. And the other change that the AIA brought to us was broadening the prior user right. That is the right that gives a company comfort that if it uses secrecy as a way to protect some business process or other innovation, it doesn't have to worry about a later inventor coming along, getting a patent, and blocking the company from deploying the innovation that it created. So, Ray, over to you for the next one.
Oh, and Jim, actually, and before we leave this slide, I'd like to add, you talked about both inbound and outbound risk. And in the distant past, like decades ago, companies could develop a product or service all on their own without interacting with anyone else. The reality is these days, you have to collaborate. Like it's
Right.
almost 99.9% guaranteed that you will collaborate with others. And as part of that relationship, there will be information flowing in both directions. So to me, it's almost a requirement in business today that you collaborate and share valuable information, confidential information. And we all have to keep aware of the risks as well as the opportunities of doing that, because it is absolutely essential to modern business.
Yeah, you're right, Chris. I mean, there have been a couple of very profound changes since the time I started doing this in the early 1970s. One is that back then everything was on paper. We had no networks, we had no cell phones. You know, the level of risk was not what it is today, and all you needed to do was guard your photocopier and watch who went in and out the front door. These days, not only that has changed, so we're in a digital environment, which is inherently less secure, but we also have these external requirements that we collaborate and share information, sometimes with very long supply chains. And a lot of vendors and customers require us to share information of ours and of theirs. And so that raises the level of risk and the need to actively manage those risks.
That's right. So we'll switch to Ray for slides 9 through 14.
Yeah,
Take it away, Ray.
I appreciate that, Chris. I feel fortunate to be here and to be on the panel with you and Jim. What I really want to talk about is the trade secrets being used as an additional tool to protect intellectual capital and intellectual property, because it has to fit within the scheme of what you're doing otherwise. And Jim is right. Certainly there has been an erosion of the power of the patent over the last decade and a half, starting with the AIA, but certainly being reflected in court decisions. And I think the emphasis on trade secrets continues to be shown, even with the most recent sort of FTC move as it relates to non-competes. And I think that emphasizes the importance of trade secrets. But again, if you go to the next slide, I want to make sure that the audience appreciates that the trade secret fits into the toolbox of protecting intellectual property. And there are traditional mechanisms to protect intellectual capital, and the kind of intellectual capital that, one, can be easily reverse engineered, or that you have to disclose for whatever reason. I think turning to patents as a mechanism to protect that is a tried and true way of protection. And certainly to the extent that it's tangible expression, using copyright becomes an important feature to protect that. And then I think most people are familiar with what constitutes a copyright and how to protect that. And certainly trademarks, protecting a brand and the source of that information, becoming known as a supplier of great information, great ideas, and associating certain goods and services with a brand or an ornamental design. And I think design patents as well, protecting something that you have to protect its functional expression, and you just can't keep it as a trade secret. And I think, using that in the full context of the toolbox and recognizing that trade secrets require some type of obligation so that there's a misappropriation, so that if someone can reverse engineer your material without doing anything wrong, then trade secrets aren't appropriate. But certainly in the context of this world where we share information, I think trade secrets become a very important part of that toolbox. And if you'll go to the next slide.
Yeah, and Ray, we all think of patents as being incredibly broad, being able to protect products and methods of making or using things. The reality is trade secrets are much, much broader. It's an incredibly broad category.
It's an incredibly broad category. Again, I think in terms of sort of technical advancements, but certainly customer list, all kinds of things to be considered a trade secret. A couple of the other distinctions, you don't have the jurisdictional limitations when you protect a trade secret. Certainly when you file a patent, you're limited by the number of jurisdictions you can go in. You're also limited by the time that you could protect that. So I think the world is shifting in the patent space to no longer pursue these broad patents where you, as Jim said, you're required by best mode to disclose everything that you know, or an enablement requirement. But instead, I think it's shifting to using patents to protect discrete species or concepts that are limited, so that you're not disclosing the keys to the kingdom. That might be the trade secret on how you arrive there. And some of the trade secrets that we've seen in the pharmaceutical space, for example, how you prevent a polymorph from forming might be, or how you have a polymorph form might be a change of 1 degree, or allowing, the escaping atmospheric conditions, things that you're not required to disclose in your patent application to achieve an enablement or even a best mode, that you can still maintain as a trade secret and keep that information protected. So I think if you go to the next slide, I think understanding what a trade secret is in some levels very intuitive. And that is that it's information that other people don't know or can't readily ascertain. But I think it's also to certainly consider the other requirements of trade secret. And that is that there is an independent economic value associated with that trade secret. And tying that to an economic advantage becomes very important ultimately when you want to go out and enforce that trade secret. But I think one of the more important aspects are the measures that you take to protect that information that you construe as a trade secret. And Chris, you and I have had debates over, everything from cataloging trade secrets to treating trade secrets at differential levels, depending on the nature of those trade secrets. But what I think is really important is to get a handle on the measures that you take ultimately to protect those types of information that you don't want to get out. Certainly, another major change in the law has been the Defend Trade Secrets Act, which provides sort of the first time there's been a centralized body of law that would constitute and bring together what was previously sort of a state law driven common law aspects to trade secret. And there's a wide variety of information under the DTSA, which would be considered trade secrets. And you're right, Chris, it's not just what those patent attorneys think of as technical advancements. It's any information that gives you that economic advantage.
Yeah, and Ray, if you look at a lot of the litigation, there's certainly disputes over technology, but a huge fraction of the filed litigation is over business secrets. So things like pricing models, margin data, competitive intelligence, even vendor relationships and customer relationships that to a traditional patent attorney is kind of less interesting. Like we tend to focus more on technology, but all that business stuff that to a patent lawyer might seem kind of normal or less interesting is heavily litigated in the industry. So this stuff is really important.
Yeah, absolutely. And not only, I think, ignored by the traditional patent attorney, but overlooked. The value of that customer list. You know, we are so enthralled by the fact that we have a technical background. And that's what entertains us, is that technical advancement. We sometimes overlook or fail to recognize the reason the company is having the success it has is it's because it's went through all of these efforts to develop business processes that give them an economic advantage. So next slide. Oh, go ahead, Chris.
No, go ahead. It's fine.
So to your point, really what I think we try to lay out here is the vast array of things that can be considered a trade secret. And importantly, many of these things have been determined not to be patentable. So, you know, the concept of using source code or, you know, as software in the US becomes very difficult to patent because we've went through this process of identifying things that are ineligible subject matter. So I think trade secret provides an opportunity to protect things that we would have traditionally tried to protect by patent, but the courts have consistently said that's not an appropriate or eligible subject matter. And the point of negative know-how, I want to tie that back to patents as well. There's been this real shift in patent law to give these broad claims because, frankly, they're just not enabled. And as we see the millions of possibilities that might come from an attempt to make a patent claim, the courts have consistently said, you haven't enabled those things, and you don't know those things that work and those things that don't. But what I can tell you by interacting with the patent office as much as I do, knowing what doesn't work becomes as important or maybe even more important than knowing what does work. Because you may have an isolated example of something that works that you describe in that patent, but you're able to keep out of that patent all of the range of things that don't work and give you that economic advantage. So
indeed,
I think,
you know, Ray, this is what protects all of R&D because it's the exploration about what doesn't work that leads you to the thing that does work. Remember what Thomas Edison said, you know, he tried 1,000 different materials for the filament, for the light bulb. And he said, I haven't failed. I've just found 1,000 ways that don't work.
Don't work.
And he could protect that from his competition.
Absolutely. Absolutely.
And Jim, could you explain a little bit more for the audience about how or why negative know-how is valuable? Like if my competitor were to find out my negative know-how,
yeah,
why would they be excited and why would I be upset?
Well, they'd be excited because they've just saved themselves probably years of effort and a whole lot of risk in knowing whether things, you know, turn out right or not. So it's catching up in a way that's unfair. It's like entering into the race halfway through when you haven't been running it and you take on the advantage that someone else has built. So that's why the competitor wants it, and that's why it's important for companies to to protect that kind of information so that their head start is protected.
Yeah, and I've found when I speak to clients about negative know-how, it's very counterintuitive because we're all trained from birth basically to think in terms of what works, what's successful, what
Right.
achieves a goal. And negative know-how it's a little hard to wrap your brain around because it's actually all the stuff that failed or set your hair on fire unintentionally. It's all the
Well,
bad stuff, but it's super valuable.
and for most businesses, you just think about it in terms of R&D. Would you want your competitors to come in and browse through your R&D function and all records and so forth? Of course you wouldn't. When you think about it, it's negative know-how that is what's at stake.
Yeah, and Jim, one of the things that struck me is during your portion of the discussion was the old school patent lawyer that would put everything in the kitchen sink in a patent application.
Right.
And there's no real need to do that because you're never going to get
certainly not anymore.
Not anymore.
Yeah.
And you still see it happening time and time again. Yeah. And it applies to, companies feeling that because they have an NDA in place. Now they can disclose everything that they know. And there's this sort of scientific pride that comes from sharing the information that you know when it's not really necessary for the evaluation at hand.
Yeah. And this might be a good place for us to emphasize that trade secrets form an important part of the patent process because when you file a patent application, it remains a trade secret up until the moment that it's published. I mean, I used to run the international patent system for the UN. And one of my nightmares was that the 200,000 patent applications we got every year, we might prematurely publish one of them or it might get out, so forth. And so a big part of what we had to do was making sure that those things were protected because in the patent process, we start inherently with very valuable trade secrets.
Yeah, we've actually started to take an approach to trade secrets that I'm going to call trade secret prosecution. Well, when we prepare a patent application in a provisional format, we're going to treat it as a trade secret until it publishes because we may not publish it. And if it doesn't publish, it becomes a great recorded record of what we consider to be a trade secret. And so we now docket that, we revisit that to see if it's been published anywhere, how we've been handling it going forward. So I think, that the point of the multitude of unfiled patent applications that have been just forgotten when they could have been sort of managed and recorded as very valuable trade secrets is a great point.
Well, indeed. And I think part of the message that we're bringing today is active trade secret management is one of the things that has changed in the corporate environment, whereas we used to think of the patent committee as a place that just said yes or no. And if we weren't going to file the patent, then it sort of fell on the cutting room floor. Whereas these days, it's much more of an innovation committee, and we're deciding which IP approaches do we use to maximize the value of this asset. And secrecy is now identified and managed actively.
Yeah, absolutely. And I will tell you, and I've told Chris this, the place that I see the value being a transactional IP strategist is when someone in a due diligence asks a trade secret question, and then I'm able to produce in a privilege log format those records that I consider to be trade secrets and or how I'm managing those and how I'm differentially treating those. It places both value on it and ends the inquiry on how, the degree that I've seen a tremendous amount of value placed on it when you can actually identify it, as opposed to answering the standard question of, how do you do your trade secrets? Here's my IP guidebook that says how I treat them, but I don't really know what it says and I never manage it that way.
Yeah, I'm sure you've seen this. There's so many times in due diligence and M&A transactions where the trade secret assets are just left undefined, and people, move merrily along with
Yeah.
an assumption that they know what's happening and what the risks are, and they don't.
Yeah, that's exactly right. That's
Yeah,
exactly right.
and another observation from this slide is most of these trade secrets you couldn't protect with traditional government registered IP. Like, if you have a customer list or negative know-how, it's kind of nonsensical to even say, oh, well, I'm going to patent my customer list, or I'm going to get a trademark on vendor relationships. Like, the traditional forms of IP just don't work. And trade secrets are a fantastic way, and often the only way of protecting these assets.
Yep. Absolutely. You can go to the next slide, Chris. So, if you want to take a step back beyond all of the reasons we've talked about, why is there so much attention on trade secrets, and why do organizations manage their trade secrets? I think you can go to Jim's slide on the damages side of it. There's just an initial reason why you see the value of trade secrets increasing. I think if you look at jurisdictions like the ITC, which you used to be able to take a patent to and stop the import of infringing articles, you now see them emphasizing trade secrets and really de-emphasizing the value of patents at the trade secret, or at the ITC level. So I think organizations should be focused on managing their trade secret fundamentally to prevent sort of the economic disadvantage that comes with others taking, misappropriating, stealing, as it were, the work that you've put in to have the market advantage that you do. And one of our colleagues has a great slide that says, what's the best way to compete with someone in the field? It's to steal their technology, right? And that's comes from, steals maybe a word that's charged, but taking employees that have information, hiring away technicians, those are all ways to misappropriate that technology. And Chris, one of the conversations that we had leading up to this was avoiding the contamination concept. We've always looked at filing patent applications before you get into a collaborative relationship as a way to mark your bills, so that down the road, if someone did take your information, you could identify it. But it also allows you to unwind and identify down the road where you might have been contaminated, and you can show that you haven't been contaminated. So avoiding contamination with others' information by actively managing trade secrets becomes really important. And we'll talk a little more about what reasonable measures are taken. I think reasonable measures should be measured in the context of the trade secret that you are protecting. And one of the things I do want to caution about is this sort of blanket approach to protecting your trade secrets, that everything is a trade secret and everything is treated at the same level of priority. In my view, the reasonable measures should be in the context of how big of an organization are you? Where does that trade secret fit in the value proposition? And ultimately measuring reasonable measures by that standard. And I think ultimately what we're looking at is trade secrets being another form of intellectual property that increases the enterprise value.
This is right. You brought up a point about reasonable measures. I just want to emphasize this is an area I address a lot. And you can get beguiled by some of the lists that are out there and people suggesting here's a checklist of all the things that you need to do. And in reality, what we're dealing with here is another aspect of business risk management, and all risk management has to be contextual to the risks that exist in that circumstance. And so you have dynamic risks that apply to dynamic assets. And so it's something that requires an individualized look and a bit of creativity sometimes in deciding what's the best thing to do to reduce the risk that something wrong will happen with this asset.
Yeah, that's right. And not every trade secret is created equally. Right. Like there are some that are the lifeblood of the company, and if they were lost, you'd have catastrophic results. Other ones are
Right.
kind of marginal value or, lower value. And just like if you have your assets at home, the ones that are more valuable, you'll protect better, and the ones that are less valuable, you'll protect less. And this is coming up on an upcoming slide as well.
Yeah, I think it's the next slide, Chris, which sort of gets
There we
into
go.
what are the reasonable measures. And, the traditional lawyer answer to a difficult question of what are reasonable measures to protect the trade secret is it depends. And I think the interesting thing about trade secrets is we all viscerally know the value of trade secrets. And I think we all viscerally know that there are trade secrets to be treated differently than others. And, certainly there are instances where trade secrets are so important that we don't even let employees who work together know the entire trade secret. They may only know steps of that. So I think you go through a list of first identifying your trade secrets and then sort of assessing a value to each of those trade secrets and coming up with a reasonable mechanism given the resources that you have and the budget that you have, filtered through the concept of recognizing that trade secrets require misappropriation to be an effective tool. And what I mean by that is, what is the risk of loss? And would it otherwise be, easily determined by lawful mechanisms? So if I purchase your equipment and I don't have a requirement not to sort of deconstruct it, will there be trade secrets that are less valuable than others? So I think those are the sort of the measures that you go through to establish a routine to identify and then assess how you're going to appropriately protect those trade secrets. So Chris, I think with that, I'll turn it back over to you. We might have our first poll.
Thanks, Ray. Yeah, so this is our first poll, and we'd like to get everyone's sense of how important are trade secrets in your organization relative to patents. So we have a few different categories. It'll be interesting to see how people pan out. So we'll just wait a minute and see.
And there was an interesting note in the chat before. I'm just scrolling up to find it. So Nolan says one of the bigger issues is honestly convincing the engineers, scientists, and other innovators that the patent has less value than the trade secrets. And another commenter chimed in, especially difficult if you have a patent bonus problem, which is interesting, right? You don't get, right? It's like the home runs, right? Everybody loves the home run ball, and I guess everybody loves patents because that's measured and quantifiable, but trade secrets, not so much.
Yeah, and Shai, it's a great question, and it really goes initially to building an IP culture and not have it be laser focused on patents. And some of Tangibly's clients are using trade secrets as a KPI and a reward mechanism where they track who's contributing to trade secrets. And even like one of them had an offsite event where there was a lunch and the CEO came out and photo opportunity to reward people for contributing to trade secrets. So I think we've been rewarding patent inventors for decades now, but we're starting to see a shift in awareness to recognizing people's contribution to trade secrets, because they might come up with a fantastic new idea or new technology that the committee chooses not to patent, but it still has tremendous value and they should be recognized and rewarded.
Yeah, if you want to see a particularly robust example of this, just look up TSMC, which is in the headlines for other reasons these days. But they have something that's called the Golden Trade Secret Award program. And it's an example of what you can do. And I've looked at how this has actually been implemented. And the fact is that they have more engineers participating in that program than they have participating in patenting. And so it's been enormously successful for the company.
Okay, Shai, so I think we'll wrap up poll one. It's actually a little surprising and very good to see that a lot of you are valuing trade secrets equally or maybe more than patents. So this is personally surprising, but an awesome result.
Well, on the other hand, it's consistent. It's consistent.
I had the very same thought, Chris, when I saw 58% recognizing that it's as valuable or more valuable than patent.
But this is consistent with the National Science Foundation survey of companies that focus on R&D intensive procedures, and they found that those companies value trade secrets at twice the level of patenting.
That's fantastic. We're doing our job properly. So we'll go ahead. So I'm going to talk about trade secret risks and how do you control them. And the risks really fall into a couple of different categories or buckets that we'll talk through. So the first one is people. And one of the reasons that I like patents but love trade secrets is trade secrets are very personal. It ultimately comes down to typically one individual or maybe a small group of people that are doing something wrong. Versus patents, which tend to be a little impersonal, like they tend to involve a big entity battling another big entity, but it's not really at the people level. So trade secrets, the people risks really fall into, in my mind, three categories as far as when the risks appear. The first one is onboarding. And a lot of people don't think about hiring a new employee as carrying a lot of risk. We're excited to hire a new engineer or a new scientist or new executive, but the reality is there's considerable risk that they will bring trade secrets from their previous job into your organization. And HR is probably your best friend or your best defense on that first day of employment to make sure that you're not being contaminated by the incoming trade secrets. And I referenced don't ask, don't tell in a way that we want the new employee to not disclose any of their previous trade secrets to the hiring organization, but also the hiring organization should not be asking them to reveal any of their trade secrets. So it's really, you can't erase people's brains because you're hiring them because they are fantastic at their job and they're bringing expertise in. But at the same time, you want to be very mindful on that first day of defense to make sure that they're not bringing in trade secrets that will cause trouble down the road. The second one is probably the best ROI, best return on investment of anything that you can do, better than software, better than lawyers, is really training and education. And earlier I mentioned that building a culture of understanding IP and understanding how to identify and manage trade secrets is supremely important. And a lot of the risk of things going wrong are actually addressable through training. There's a lot of risks that are kind of naive, or people just didn't know something was wrong, or they didn't know something was a trade secret. That's all very addressable. And then the last one, a fair number of people or most people do think about is the risk of offboarding. When you have a key employee or a great engineer leave your company to then go typically to a competitor, or in some cases, they might set up a competing business of their own, that's a huge people risk point of you want to be very clear, ideally in an exit interview or in some documented process, that they're not going to take documents with them. They're not going to take information and trade secrets from your company to the new company and then give them an unfair advantage. So all three of these steps, so as you're hiring, as they're employed, and then as they're leaving the organization, you need to be very mindful about lowering your risks as much as you can. Ray and Jim, how does that resonate with you guys as far as advising clients on how to keep their risks low?
No, I think that's spectacular. But one of the things that I for the audience's benefit, I have the great privilege of knowing Chris for the last couple of decades, and either worked for him, he's worked for me, and we've worked together. But taking what is the epitome of a patent lawyer in the space and hearing from him that I like patents, but I love trade secrets, I think really emphasizes the importance and the shift of trade secrets. Because Chris, 15 years ago when I was doing diligence on a company of yours, trade secrets didn't even come up in our diligence discussion, and now it's become a center of many topics. But no, I agree on sort of the concepts of making sure that you integrate human resources and the hiring concept with the hygiene that's required to avoid trade secret misappropriation.
Yeah, let me just add one comment on the onboarding part. When you have people coming in, the ones that are coming in, don't necessarily trust them when they say, yeah, I don't have anything, because they often forget about information that they've stored in some private locker somewhere, digital locker, or have at home in the junk drawer and so forth. So the more important the person, the greater the amount of scrubbing that you have to do. And then don't neglect the people who are going to be their new colleagues, because it's important that they know there might come a time when this person has to step out of the room, and they have to be okay with that. So if it sometimes takes some active management to make sure that people are ready for this kind of transition that helps keep the risk down.
Absolutely. And we're going to keep moving ahead. I know we're having a great conversation, but time is ticking. So there's also procedural risks that are addressable through things like trade secret policies or part of an IP policy. There's also a lot of great IT tools that are available from software providers that look for aberrant behavior or unusual behavior. And if you read a lot of trade secret litigations, there's kind of typical patterns, like a departing employee at 3 a.m. downloads 3,000 files instead of the 10 files a day that they normally do. So there are a number of technology tools that can help spot problems, as they're occurring.
Generally called DLP,
yeah,
data loss prevention tools.
Correct. And they work amazingly well. And again, like a lot of people who take trade secrets do it in kind of normal ways. Like you have to be more and more creative to avoid these kind of tools spotting you. And then it's important to limit access on kind of a need to know basis. And it might be a large group, like you might have 50 engineers who need access to a trade secret, which is fine, but it shouldn't be on a shared drive that all 10,000 employees can access, whether they need to have access or not. So there's a lot of good tools available.
Yeah, and Chris, on the policy consideration, one of the things that I, again, would provide some guidance on is to not try to do everything in the same policy guideline. I've seen this way too often where every consideration from national security interest to share NDAs everybody's trying to address that in policy guidelines, which ultimately results in people not following the policy as a matter of as a rule.
Really good point, Ray. And keep in mind too, the fundamental imperative, we manage to the risk and not to the rules. The rules can be dynamic just as the risk is.
Definitely. Okay, so quickly we'll do a second poll, and we'd like to get a sense of kind of if you had to self-score yourself, how well does your organization protect trade secrets? All the way from awesome, you're at TSMC already, gold standard, all the way down to, there's lots of room for improvement, and you've learned a lot of things today that hopefully you'll start implementing in the future. So we'll see how people stand.
Yeah, so Chris, I want to take a minute or two to address some of the questions in the chat, because I've seen some of the same questions come up. Of course, everybody knows that the FTC just passed a non-compete rule, and that is going to create lots of headaches and problems for protecting trade secrets. So would love the panel's thoughts and reactions and guidance on that. Jim, we'll start with you.
Yeah, I have two quick comments. One is it's likely not to go into effect. I mean, there's been challenges filed already, and yet, even if it doesn't, even if the FTC rule doesn't destroy all non-competes fundamentally across the country, we still have to understand that non-competes are an endangered species. because the states have been engaging new legislation. So whether or not your state, like California, will outlaw them, the fact is that your business operating across state lines will be having to deal with a variety of different standards that ultimately might make it completely impractical to try to use non-competes as a way to protect trade secrets. And so we're probably going to all have to eventually get to the place where we rely more on enforcement of trade secret obligations than we do on non-compete obligations. So that's one of the reasons why this area is important.
Yeah, and just to add to that, we do have a slide coming up that now we can skip over about this. And Jim and I were at a conference just last week where this FTC ruling kind of dominated the conversation and a little bit hijacked the conference. But in my mind, non-competes are really designed to prevent the movement of people, but indirectly they protect trade secrets. And
Sure.
as non-competes get eroded and possibly eliminated, you have to protect trade secrets directly instead of indirectly. So in a way, the FTC's action and the gradual erosion of non-competes just makes protecting trade secrets more critical for everyone. So it's sort of great news for those of us in the trade secret business.
Well, I mean, it's a wake-up call, right?
It is.
And I think the focus on non-disclosure agreements and non-solicitation agreements become much more direct, not relying on sort of the non-compete angle. I was really interested on the poll. There were 5 people out of the gate who had awesome protection. And then, they continued to dwindle. And then there was a couple late joiners. So that was a lot of fun to watch.
Definitely. Okay, so we'll close the poll and keep moving. So yeah, here's the FTC slide, which we just really covered well. It's definitely the hot topic of the month and probably the whole year, and we'll all be watching very closely.
Yeah, it displaced artificial intelligence.
It did so quickly.
Like to talk about.
Well, it was funny. Like AI was totally dominating everything, and now it's like, oh yeah, AI. But the FTC really took over. So here's a slide on what I think are kind of interesting aspects of trade secrets. And again, I'd love to get Jim and Ray's perspective on some different things, like different from patents. And certainly the ITC Ray mentioned earlier, I think the criminal liability is interesting and can be a really scary deterrent for employees to act properly. And then there's this whole notion of patents cost money because there's a filing fee to the government, but trade secrets are free in a way, in the sense that there's no government fee. But I often find people say, oh, I don't have to do anything, or it's somehow free protection. And I think that's a total fallacy. So over to Jim and Ray, let's kind of walk through these and see what you think.
Well, I mean, the ITC exists as protection for U.S. borders against the importation of goods that have been infected somehow with intellectual property violations. And traditionally, it's been used for trademarks and patents, but beginning with a case that was decided back in 2011 called Chan Ray, the Federal Circuit confirmed that trade secret misappropriation that happens overseas can be the source of an ITC claim, because the products, once they reach the shores of the U.S., are subject to in rem jurisdiction by the ITC. And since that time, there's been a number of cases that have challenged the trade secret integrity of products that were made overseas, and where the manufacturer wants to bring them into the U.S. And so there's been very marked increase in the number of cases. And of course, the ITC is an agency that has to determine these cases within a year. So they're very, very fast moving, and they can result in exclusions from the U.S. In other words, the products simply can't come in. And that that marks something of a distinction with, patent cases in normal district court enforcement where getting injunctions is very difficult. In the ITC, it's the primary remedy.
Yeah.
Ray, if you want to jump into this, I know you guys handle a lot of these kinds of cases.
Oh, we do, and I think we see a real move to trade secrets at the ITC because of the breadth of the exclusion order. So, it's now very, it's very difficult to get a broad exclusion order when it comes to a patent, and that becomes a very specific issue. But on the trade secret, you find an ability to do that, and I think that can be used as a lot of leverage. But Chris, one of the things I wanted to talk about is the not free concept, and that is true. Looking at the world in a binary way of free and not free is one thing, but I will tell you, and as a 30-year practicing patent lawyer, it's hard for me to say this, but the relative value of good trade secret hygiene and the protection of those things that are valuable and being able to do it immediately relative to the patent protection that can be often misunderstood on the breadth of the patent protection, and without having sort of economic success that is associated with that patent can result in what I often refer to as a bad insurance policy, because you've spent a lot of money and time on this patent application and there's not a correlation to the product that you're trying to protect, where that it doesn't happen in the concept of good routine hygienic approach to confidential information and trade secrets.
Yeah, I really do agree with that. Although it's not free, trade secret protection is, generally speaking, in most companies, especially large ones, much less expensive. I mean, it takes mostly attention as opposed to money to provide a much better level of protection. We should say a word about the criminal aspect of trade secret enforcement. In this sense, you probably will want to, if you're an active technology-based business, you may have issues with turnover and people leaving and going to competitors. It's a good idea to get to know your local friendly FBI agent, so that in case you need their help, you know who they are, and also they can give you a lot of good tips on protecting technology that you could put to use at the company, regardless of whether you have a problem. But if you do, just keep in mind, you need to think carefully about handing a case over to the authorities, because once you do that, you lose control over it. And one of the most interesting aspects of trade secret dispute management is that you have many, many opportunities to resolve the dispute and move it off the court, move it out of court. And that becomes, of course, enormously more difficult if there's been a criminal case filed or even an investigation started.
And at the conference last week that Jim and I attended, there was a special agent from the FBI on one of the panels, and his insights into that process and the pros and cons of it were really interesting. And Jim, you're right, you do lose a lot of control, but it can be used successfully. Like there was a Genentech litigation that Nicole and I talked about on the last webinar, where people went to jail over trade secret theft. And there was someone from Genentech saying that it was partially for the people who went to jail, but it was also, even more importantly, to send a message to all the other employees that if you do things badly that results in a loss to Genentech, bad things will happen to you. So again, to me, it can be used carefully as a great deterrent to keep people walking the straight line.
Yeah, there's nothing like, I mean, I have participated in a search warrant execution, and there's nothing that concentrates the mind like people busting through the door with loaded guns and saying, get your hands off that keyboard.
Yeah. It's pretty scary. And then just finally, before we move on, on the last one, the protection is not free. Ray, that actually came from a conversation that I had with a partner not at DLA, but at one of your competitors. And when he said that to me, I almost fell out of my chair of, it should be free. I'm like, no, this is a super valuable asset. You need to do something. Like doing nothing is unreasonable. We talk about what's reasonable measures, but the opposite's also true. So we'll move forward. And we have a couple of interesting cases. Jim actually was very much involved in the first one at the ITC. And then the second one is hot off the press a couple of weeks ago from the Sixth Circuit about demonstrating reasonable measures. So Jim, maybe you could just briefly spend a few minutes on the ITC case.
I mean, basically this is the ITC case. Yeah, that was one, again, interesting and unusual because it was between two Korean companies, both coming to the US to set up operations. And LG Chem, which was the side that I represented, filed a complaint that the SK Innovation folks, by hiring dozens and dozens of engineers away from LG Chem, had acquired a bunch of information. Well, it was an intensively litigated case, but at the end, it was resolved because SK Innovation was found to have spoliated massive amounts of documents. They had a well-organized program to destroy evidence of what had happened. And so the court eventually, the ITC, entered a default judgment that resulted in a likely exclusion order that would have stopped the building of a plant in Georgia. And so there was a lot of political pressure that was brought to bear on the case, and it ultimately settled for almost $2 billion.
Yeah, it was amazing. And there's always US business connection for ITC cases where you have to show that an
domestic
American
industry.
Exactly. And this one, to me, I thought was fascinating because both companies were Korean companies. So it's an interesting fact pattern. Unlike the second one, which the facts are kind of straightforward. It involves pipe welding and getting information from ex-employees. So the facts of the second case are kind of straightforward or not very exciting. What I thought was interesting is the court required that you plead or demonstrate the actual reasonable steps that you took to protect your trade secrets. So it wasn't enough that you did it, but you actually had to affirmatively plead, these are the different things that we did that make up reasonable measures. So it's a great case for what it stands for and really reinforces this idea that you have to take specific articulatable steps to protect trade secrets.
Yeah, and basically, if you don't, the courts will say, "Well, you left the barn door open. We're not going to help you. Go get the horse back."
Yep.
So cases have been lost on summary judgment on this issue alone.
Yeah, and Chris, I think you this concept of just running to court and saying that your trade secrets have been taken is going to be under more scrutiny because of the non-compete approach. You're going to have to be able to describe how you protect it. You're going to have to be able to describe the trade secret. You're going to have to describe who's had access to it. So those are going to be things that become more and more prominent in these cases, and you see these cases leaning that way.
Yeah, your pleadings will have to be a lot more specific. You can't wave your hands like you used to.
Exactly.
And then we're going to take some time for Q&A, but all three of us obviously are super excited about what we're talking about and being here. And feel free to reach out to us either directly or through Shai and his team. Jim for expert witness and consulting. Ray and his team at DLA do fantastic work for their clients. And Tangibly is a SaaS provider. So we provide tools and toolboxes that companies can use to identify and manage trade secrets. So you have three great people to turn to. And Shai, we'll turn it over to you to have a few questions before we're out of time.
All right. First of all, I just want to say thank you so much, Ray, Jim, and Chris, for a wonderful program. It was lively discussion, a lot of great content in the chat. Folks, if you enjoyed the program, please let us know in the chat. And if you have questions, and apologies if your question got buried up above, please copy and paste your question again so we have it. I have a few questions here, so we'll get to that. Are there jurisdictions where trade secrets are not protected or protectable? For example, working with a CMO in India and sharing information with them?
There is, let me give one answer to this. There is a 2014 article survey by the OECD. If you just look up OECD 2014 trade secrets, you'll find it. And it ranks countries throughout the world according to the level of their enforcement of trade secret rights. India, I think, was 5th from the bottom, just ahead of China. So that's the short answer to that question. Yes, there's a big difference in how effectively you can get your trade secret rights enforced in various jurisdictions.
Well, and I'll add a little bit to that as well. So not every country has a trade secret specific statute. So some countries like the US do. Other ones like Singapore, you have to be creative and use other things like breach of confidence, copyright violation, computer misuse acts to effectively protect trade secrets, even though there's not a specific one in place. Now, India, I actually happen to know a lot about. I spend a lot of time there. And it's funny, in January, I spoke at 3 law schools in India, and they all asked the exact same question of when will India have a trade secret specific statute? And I gave my usual answer, which is, India will get there, but be patient. It will take time. And on March 5th, the Law Commission of India, which is a government, it's not an agency, but it's sort of formed by the government, came up with a 200-ish page report on why India needs to have a trade secret statute. And they even drafted a first draft statute for the government to consider. And it's all coming from pressure from local industry to improve. And we saw the same thing in China. China used to have a horrible reputation for IP enforcement, but the local industries needed it to remain competitive. And the system has improved ever since. India is doing the same thing. And it's great that that report came out. I wish it had come out 2 weeks earlier before I gave the talks at the law schools. But it does show that even places that traditionally have had weak enforcement rights, are realizing the value of trade secrets and are stepping up their game. So it's a great question.
China, indeed. And China has, as Chris said, vastly improved over the years, in part because of the bilateral negotiations that we've had with them and as a result of the Phase 1 treaty. So they've instituted a lot of procedures, including flipping burdens of proof and so forth, that make it easier to get enforcement of trade secret rights.
All right. I have another question, and Tim says it's a good one, and I wholeheartedly agree with Tim's assessment. The question is from Michael. Michael asks, when an employee who has had access to trade secrets leaves for a competitor, what's your view on calling the competitor and warning them not to steal your trade secrets?
Yeah, it's interesting. I was thinking about that as we were giving the presentation. I have actually used this in extreme examples where a very important inventor has went to a competitor and have written a competitor to remind them of the areas that we consider sensitive. I mean, obviously, we do that in a manner that keeps that information confidential, but I think it's a good mechanism to remind people that we understand the employee has freedom to choose his employment, but he doesn't have freedom to use our important trade secrets. So,
yeah, and I don't think you'd want to use it for everyone. Like,
right.
If an admin or your kitchen staff left to work at the competitor's kitchen, that probably doesn't warrant it, but it's definitely something to keep in mind. And how you word the letter is also important. Like, you probably don't want it to be overly hostile. Just say, hey, we noticed this employee has left our company to join yours. Congratulations on hiring a great person. By the way, we're just reminding you of their ongoing obligations. So it can be written in a very neutral or even friendly way, but it's a great way of documenting that you're aware that this person has moved and there's risks that need to be controlled. So I think using it in a tactical manner can make a lot of sense.
Yeah, if I can be excused the shameless promotion, if you go to Amazon and look for my second edition of my business book on trade secrets, there will be samples of warning letters and other, and other templates for things that you want to do in your trade secret practice.
There, you know what? If you can pull up the link, I'm happy to put it in the chat. I'm happy, and there's no shame in that at all. And I wonder if the warning letter is too, or I suspect the warning letter is too severe. Maybe that's a tip that like, hey, the person you hired has some, has access to our crown jewels, and maybe like, you don't want to be too aggressive about it either, because maybe you tip off.
Literally, I like Chris said, you want to word it in a way that you're helping them out. They don't want to be contaminated with trade secrets. They don't want to be in that position. And, we respect your intellectual property. All we're doing is asking you to do the same.
Yep.
Perfect. Next question, and then I think we'll talk about Tangibly. But the question is, in light of ever-growing threat actor risks, could providing incentives to documenting trade secrets backfire in the event of unauthorized access, aka if you get hacked? Any thoughts on mitigating these risks beyond good data security?
Yeah, there is definitely a raging debate and disagreement among practitioners on how and where you store this information. I think again it becomes an issue of how sensitive the information is, and none of us have a database that just provides guidelines on how we're going to, what our advantages. And we're using that database management as a mechanism to gauge the importance. And like I said at the beginning, there are situations where employees aren't exposed to the same information. So I think guiding, I don't want to see a repository necessarily of every trade secret that you have that could be hacked. I recognize the issue there. But I think having a centralized listing of those things in sort of a privileged format is not a bad approach at all.
Yeah, I mean, ultimately, you can't manage something you haven't defined and you're not paying attention to. So you have to engage with what are the assets at some level that's appropriate to the enterprise and to the environment that you're trying to create with employees. Again, the example of TSMC, they have been having amassed over 40,000 submissions over the years. They've developed some AI tools that they're using to go in and extract where are the centers of engineering excellence inside the organization. So the collateral benefits that they're getting from paying attention to this and corralling it are enormous.
Yeah, and there are a small fraction of people that say you shouldn't have any list, any catalog, none of that. But to me, it's hard to reconcile because every other valuable asset of the organization is listed or cataloged somewhere. So companies know exactly which real estate holdings, which factories, even down to computer monitors. Like every asset they have is well cataloged and listed somewhere, maybe as depreciating asset or what have you. But somehow trade secrets, you shouldn't have any list at all. Like it seems like a bit of nonsense to me that the super valuable asset, you should have no idea and no insight as to what's there. It just doesn't make sense.
Yeah, well, it is nonsense. It's where you're listening to people whose job it is to go tell a story in court, and of course they'd rather not have anything that they need to deal with that would get in their way of spinning it as they would like to if there is a dispute. But we have a business to run, and running it intelligently means understanding what the assets are and what we need to do in order to increase enterprise value.
Yep, exactly.
All right, let's wrap up. But first, sort of shameless slugs and promotion. Chris, tell us about Tangibly, and then we'll swing back around for final remarks.
Sure. Just very briefly, Tangibly, we're not a law firm like DLA, but we provide tools and insights primarily through our SaaS platform, but also as consultants to enable people to identify and manage their trade secrets. And we formed Tangibly to help address that vacuum where people want to identify and manage trade secrets, but they either don't know how or they don't have the right tools to do that properly. And we can either work directly with companies or through law firms like Ray's team at DLA to make the process at least easier. We have the goal of making it easy, and we'll get there eventually, but at least make it easier than before. So we're super excited to be a primary sponsor of this series with IHC.
Thank you so much. We'll go Ray and then Jim for, final remarks, and then back to Chris, and then we'll sign off for the day.
Yeah, so I appreciate that. Give a shameless promotion for DLA Piper. It's one of the world's largest law firms, has offices in almost every jurisdiction, and certainly understands the unique issues that are associated with those jurisdictions. I am an advocate of Tangibly. I found it to be a resource that I'm just touching the tip of the iceberg on the value. And over the course of the next 5-10 years, we're going to continue to see this increased importance of trade secrets. And I want to be a leader in placing value on those. So, Jim?
Thanks, Ray. And I want to emphasize that both my experience, I used to be a partner in your predecessor firm, and it's an amazing organization, and Chris Tangibly too is doing really fabulous work, which matters to me because my professional mission is elevating trade secrets to the level of respect that the registered rights have, and helping to ensure that businesses adequately pay attention and benefit from these assets. So it's a real pleasure and honor to be working with these gentlemen.
Thank you. And a real pleasure and honor to have you on with us today, Jim. Chris, last word?
Just last words. Look forward to an invitation from Shai for our next in this series. We'll be talking about litigation funding sources for enforcing trade secret rights. So it'll be a great topic. And thank you so many hundreds of people for joining us today. This is great.
Yes, thank you. Thank you, everybody. Thanks again to our panel, to DLA, to Tangibly, and to Jim for a wonderful program.